Good morning, everyone. My name's Nicolette Rubenstein. I'm your host for this morning's plenary session. A very warm welcome, particularly to our international guests this morning, and hello to those joining us online. A big thank you to our platinum sponsors, RGA, Milliman, and Actuaries. I would like to begin by acknowledging and paying my respects to the traditional owners of the land on which we meet, the Gadigal people of the Eora Nation. Also, particularly because we have international guests, I would like to acknowledge that we have a path still to go on towards reconciliation in this country. Always was and always will be Aboriginal land. So let's get to our session on customers today. The title is Trust Betrayed and Trust Regained. We have an incredible lineup for you. I'm incredibly excited and I think you're in for a treat. We're going to start off with a video from Andy Agathangelou. He is the founder of the Transparency Task Force, and this video will establish a bit of global context for our conversation. So the Transparency Task Force's mission is to promote ongoing reform of the financial sector so that it serves society better. It has 21 member countries, and Andy is also governor of the UK's Pension Policy Institute and impressively a fellow of the Royal Society of Arts. Then we will look at the past, and we will look at what has gone wrong, and we're going to use Australia as a case study. And the Honourable Kenneth Hayne AC will take us through what happened in the Royal Commission into misconduct into the banking, superannuation and financial services industry. So Kenneth Hayne is a former Justice of the High Court of Australia, and I also learnt that he was a Rhodes Scholar in the year that I was born. Anyway, we're incredibly grateful that he has agreed to speak today because he has not done many public appearances. For the Royal Commission in 2018, he had quite an unusual brief. He had a very broad brief, but also he did not just look at whether companies had broken the law. He looked at whether we had lived up to community expectations. So after Ken, we are going to look to the future and how we can regain trust. And we have consumer futurist Amanda Stevens to present to you. She has worked with the likes of Microsoft, Lend-Lease and Procter & Gamble, and she will help us imagine the future of the financial services customer. And finally, Roosevelt Mosley will help us understand what that all means for actuaries. He is the current president of the Casualty Actuarial Society in the US and a principal at Pinnacle Actuarial Resources. So to start us off, she says confidently, we have a question, there we go, for the audience. So if you can go into your app and go into the Now On icon, and if you can all answer that question. How would you rate global trust in financial services on a scale of 1 to 5, where 5 is most trust and 1 is least trust? And while you're all doing that, I just want to remind you as well, that we have time for Q&A at the end with our speakers. So you can also submit questions through your app. Okay, so now we're going to kick things off with the video from Andy, founder of the Transparency Task Force. Thank you.
Hello. I really do believe there's been a widespread collapse of trust in the establishment and the institutional pillars that have historically supported it, be they political, judicial, social, economic or financial. That collapse of trust is particularly significant to the financial sector because it depends on being trustworthy. The word credit comes from the Latin word credere, which means to believe in. If you take trust and confidence out of financial services, you really have nothing left. Given how trust dependent the sector is, you'd think it would be hyper vigilant against any conduct that corrodes trustworthiness. That would make complete sense, but that's not the reality. And to bring this point to life, I'm going to share some data about violations by the financial sector. The data relates to the UK, but there's a matching set for the USA, and I'm sure the same pattern would be seen in Australia and elsewhere. So here we have Violation Tracker UK. If you click onto the other summaries option at the bottom, which I'm about to do, you get straight to a list of parent industry totals, this one here. And that gives you a list of the parent industries totaled by how much they've been fined since the year 2010. Now, ladies and gentlemen, there's a very long list of reasons why the financial services sector, which is trust dependent, should not be anywhere near the top of that naughty list. But as you can see, it is. And it is by a long, long way. And financial services itself does seem to have a particularly concerning pattern. What we're looking at here are the 10 top offenders. And beneath that, we've got the individual cases ranked by size of fine. When we scroll down this list, ladies and gentlemen, we see a pattern of recidivism, whereby the same organizations are doing the same wrong things over and over again, being fined and then just carrying on. This gives us lots to worry about. Does it suggest, perhaps, that the cultures within these organizations are so toxic that they see being caught for malpractice as simply a cost of doing business? And of course, it also gives us concern about the regulatory approach. The regulatory approach is to fine the companies. Those fines, of course, are paid for by the innocent shareholders. And perhaps there's a woeful lack of jeopardy for the individuals actually responsible for the misconduct. And also there's a lack of focus, the data would suggest, on the actual oversight and governance and risk management controls within the organizations themselves. Of course, this is highly problematic, and it takes us to the central question for today's session, which is, how do we solve the trust and confidence deficit blighting the financial sector? I'm going to respond to that question with a metaphor about picking up litter. There are three mindsets we can have about picking up litter. The first, where we aren't willing to pick up any litter at all, not even our own. The second, where we are willing to pick up only our own litter. And the third, where we are willing to pick up our own litter and also the litter of others. That third mindset is about choosing to take collective responsibility for what we are not responsible for. And it's my belief that's the only mindset that can fix the trust and confidence crisis. This is a time for scrutiny, accountability and transparency, a time for radical change, for leadership and for refusing to accept the status quo for all our sakes. The kind of positive, progressive and purposeful reform delivered by the Hayne Commission has been a huge step in the right direction. We must now seize the opportunity to build on the momentum it's created globally, starting today. In closing, I'd like to express my hope that I've given your world-class panel some questions they can consider, such as, is there sufficient jeopardy for poor conduct at an individual level? What does all this mean for the actuarial profession? And is it time to make the paradigm shift in our thinking about what it means to be a professional, whereby being a true professional means choosing to take collective responsibility for what we are not responsible for? Ladies and gentlemen, thank you very much for listening to me. Thank you.
Big thank you to Andy for recording that for us. Okay, let's have a look at the results of our poll. Right, quite a sad state of events, I would say, but almost good in that we've accurately reflected what I think our customers do think. So very few people giving us 5 and not too many 4, and the most popular answer being 3. So think that establishes a very good context for this session about how we need to rebuild trust. So I'm now going to ask the Honourable Kenneth Hayne AC to join me on the stage. Please join me in welcoming Ken.
Thank you very much, Nicolette. Ladies and gentlemen, having passed the first hurdle of climbing up onto the stage without tripping over, let me begin. Now, as has been mentioned, it is now about 5.5 years ago, in late 2017, that I was asked to conduct the Royal Commission into Misconduct in the banking, superannuation and financial services industry. In the 14 months that followed that, until I submitted my final report in February 2019, was a period of intense work. Whether and to what extent the inquiry revealed what had gone wrong in the industry and why it went wrong is for you and for others generally to judge. What I discovered, what I thought should follow from what I found, is set out in the reports I made. Those reports can and should speak for themselves. Even so, it may be useful to say something about the work that was done in the Commission, with a view to seeing whether you think that there are propositions or ideas identified in that work or from that work which may have some more general application. And to do that, it's important to provide just a little background. The Commission was established at a time when there were as many as 70 public inquiries had been or were then being conducted into the conduct of banks or their associated entities. In addition to those public inquiries, regulatory authorities had conducted and were then continuing to conduct inquiries into allegations of misconduct. And before the Commission was announced, the 4 major banks in Australia had publicly acknowledged that their conduct or the conduct of associated entities had fallen short of what the community expected. So that set the scene for the inquiry. I began the inquiry, as many of you may recall, by asking financial services entities, including, of course, the banks, to tell me what conduct they had identified over the preceding 10 years that might amount to misconduct or conduct that fell short of community standards and expectations. The replies were interesting. Some entities made detailed responses. Others said, in effect, that their records did not allow them to assemble information of the kind I had sought. And during the life of the Commission, members of the public submitted more than 10,000 complaints about financial services entities by using the Commission's web form. And on top of that, of course, there were many thousands of phone calls and emails to the office of the Commission, some asking for help about making a complaint, some asking about the work, some offering comment on the work. But for the moment, 2 points follow that I want to identify. The first is that when the Commission began its work, there was a well of public dissatisfaction with participants in the industry. And second, By the time the Commission was appointed, major players within the industry had accepted that their conduct, or the conduct of associated entities, had fallen short of what the community expected. That is, members of the public thought there were problems, important participants in the industry agreed. Now, as I've said, the reports I made set out what I found, and it is not, I think, productive now to rehearse the findings or the recommendations I made. Instead, I want to take three quite general sets of propositions that can be seen in the Commission's reports and invite you to consider whether the propositions may have more general application. Much of what was seen and observed during the work of the Commission invited consideration of four subjects: the connection between conduct and reward, asymmetry of power and information between providers and customers, conflicts between duty to customer and the interests of the provider of products or services, and fourth, how were entities being held to account? So let me say a little about each of them. First, the relationship between conduct and reward. It is a truism that misconduct is often, even usually, driven by the actor's pursuit of commercial gain. It's equally obvious, though apparently unrelated, that income, profit and sales can all be measured and monitored. But compliance with the law and ethics cannot be measured in the same ways. If an individual is remunerated according to income or profit generated or sales made, the individual's pursuit of higher remuneration may swamp other relevant considerations, including considerations of compliance with the law and compliance with basic standards of probity. And there is, therefore, I think, a connection between conduct and reward, and the connection may obscure the need to look at how the actor has generated the sales or generated the income. But if there is that connection between conduct and reward, what follows? Is the remuneration system increasing the prospect of misconduct? If it is, what should be the response? The second subject is asymmetry of power or information. If there is an asymmetry between power and knowledge available to the consumer and power and knowledge available to the supplier of the goods or services has power or knowledge the customer doesn't have, and the customer of that supplier cannot bargain effectively with the supplier. And if the customer cannot bargain, the customer has a binary choice: take what is offered on the terms offered, or simply refuse to take the goods or services that are offered. And if the customer does not know or cannot make an informed assessment of the characteristics and value of what has been offered, the customer will make the choice, not knowing whether what was offered will be fit for the purposes the customer seeks to buy the goods or service, and not knowing whether there is some better product or price available elsewhere. But again, if the asymmetry is observed, what follows? Does it create, does it increase the risk that the provider will supply inappropriate products to customers? If it does create or increase that risk, what should be the response? Asymmetry of knowledge and power is then exaggerated if a customer is seeking advice from the supplier of the product. And that leads, of course, into consideration of conflicts of duty and interest. If a customer seeks advice from a supplier about what would suit their needs best, have you ever encountered a case where the supplier has ever gone beyond saying, my product at my price is best for you? And if the customer cannot make any independent assessment of fitness for purpose and cannot make any useful price comparison, the customer makes the choice to accept or reject what is offered according only to whether the customer trusts the supplier. And often the customer does that by reference only to the supplier's reputation. So what happens to that reputation if the supplier sells products to customers that are not appropriate? Now, the problems are exaggerated still further if the supplier carries on a business of providing advice. It will be even greater again if the supplier of advice is remunerated by the maker of the product that the advisor recommends. What is the duty that the advisor owes to the client? The advisor holds itself out as providing advice, and providing advice is a task different from selling a product. Is the customer entitled to treat the advisor as acting in the customer's interests? Is duty to client to act in the client's interests compatible with the advisor having a pecuniary interest in what product the client buys or how much of the product the client takes? To adopt a metaphor I came across in a very different context, can the advisor stand in more than one canoe? Some provisions of the Corporations Act, which deal with financial advice, speak of a need to manage conflicts of interest. But can conflicts of interest and duty be managed? How? Should we be surprised that often, very often, persons whose personal interests conflict with their duty to a client rationalise the conflict in a way that accords with their personal interest? Or is that just being too cynical? If there is a conflict between the interests of advisor and duty to client, how does the advisor act to protect itself against the client when what is sold to the client does not perform as the client hoped? The accusation will be that the advisor looked after itself, not the client. Then what about regulation? If an industry is regulated, what's the regulator's role? Will those who break the law be held to account? Will others be deterred from breaking the law? Or will regulatory intervention be little more than a nuisance or cost of doing business? The size of those costs was illustrated in the slide we saw in the film that began this session. And will regulatory intervention occur sufficiently quickly to change behaviour in the market? Now, those are issues that participants in the market may say are for regulators to confront. But if there is not appropriate regulatory response to misconduct, the entire regulated industry will come to suffer. The so-called bad apples will multiply. Public dissatisfaction with the industry generally will increase. And none of that is good for individual participants. So what then should the individual participant in the market do to reduce that kind of risk? Now, issues of that kind ran through much of the work which the Commission did. But you may conclude that the points have more general application. If that's right, the considerations I've mentioned, namely connections between conduct and reward, asymmetries of power and information, conflicts between duty and interest, and how entities are held to regulatory account, are useful to examine when considering how any commercial enterprise is organised and operates. They are useful because they point to various forms of risk that the enterprise is facing. And of course, identifying what the risks are is the first step in preventing their occurrence. But the answers you make to the 4 questions I've mentioned must then provoke some further examination of why you give the answers you do in relation, whether it is to a particular entity or to some group of entities. And they will cause you, I would hope, to identify the standards against which you are forming your judgment. I would say that in any event, it is desirable, even necessary, to identify the standards which an enterprise and those dealing with the enterprise might use in considering how well it is organised and how well it operates. Because identifying the relevant standards should help to identify the nature and extent of the risks to be considered when deciding how well it is organised and operates. The standards are most usefully identified as simply and directly as possible. In the context of the financial services industry, I identified 6 fundamental norms of conduct or precepts. But the question for you becomes whether those norms of behaviour or something like them can be applied more widely. The 6 were: obey the law, do not mislead or deceive, act fairly, provide goods or services that are fit for purpose, deliver goods or services with reasonable care and skill, and when acting for another, act in the best interests of that other. Now, each of those is widely accepted, well established, easily understood. But of course, all of them will find some reflection in the law. But expressed in the form in which I have, they may provide a more useful framework for judgment than simply saying that an enterprise must obey the law. Too often the applicable law is found in many different places, and there is often then a tendency to become lost in the wood. You become immersed in the details of the law without focusing on the basic norms of conduct that underpin the particular legal provisions and also reflect what customers and society more generally expect of enterprises. But as I say, it may be useful to consider whether the 6 ideas I have mentioned sufficiently capture what the public expect and should be entitled to expect when dealing with a commercial entity. If these ideas do capture what people can and should expect in dealings, is this what is happening? Of course, there will be deviations. Commercial enterprises and activities are human endeavours. There will be participants in every commercial area who break the law, who do mislead and deceive, who do not act fairly, who do not supply goods or services fit for purpose, don't act with reasonable care and skill, or if they're acting for another, prefer their own interests to the interests of the client. It's a human endeavour. But are the deviations too frequent? Are they persistent and widespread? And whether or not they are persistent or widespread, you must inevitably go on to consider a third set of issues: leadership, culture, governance. Of course, if there are persistent or widespread breaches of the norms I've identified, it would say a lot about leadership, culture and governance within the entity or relevant entities. But if there are only occasional deviations, what is it in the leadership, culture and governance of the entity that is contributing to that result? Identifying what is contributing to the result is just as important if there is no default. Now, governance of the entity will shape how it is run and operates. How it is run and how it operates will shape its culture. And of course, how it's run includes its systems, controls and risk management processes. Again, it is a truism to say that the tone of an entity is set at the top, but that the tone has to be echoed from the bottom. And it has to be reinforced at every level of the entity's management and supervision. Poor leadership, poor decision-making, poor behaviour all undermine the governance framework and the culture of any entity. Good leadership will yield good governance. Good leadership and good governance will yield good outcomes. Remuneration and incentives tell employees what an entity values. Remuneration both affects and reflects culture. That is why, to loop back to the first set of issues I looked at, adopting some forms of remuneration and incentive programs can lead not only to poor outcomes for customers, they can lead to a breakdown in culture and misconduct. Now, since the GFC, there has been a lot of attention given to culture, governance, remuneration. In the financial industry, work in the area has been led by the Group of 30 Consultative Group on International Economic and Monetary Affairs, the so-called G30, and by the Financial Stability Board, the body that monitors and makes recommendations about global financial system. Here it's been supplemented by work done by or for the Prudential Regulatory Authority. So even if you confine attention to the financial industry, there is a wide body of material about culture, governance and remuneration that will repay examination. And there is no doubt much more out there that will repay your thought and your consideration. So 3 sets of propositions, all of them linked one to another, that I thought emerged from work I was doing from late 2017 to early 2019. As I say, although I've treated them separately, you will see how they overlap and intersect. And that's surely not surprising. Even so, You may find it useful to look at the issues in the way I have described. I hope you do. But do that knowing that my description of the issues was born in the context of the inquiries I was asked to make. It's for you to decide whether they can be usefully applied today beyond the areas I was required to examine. Thank you.
Thank you. Excellent. So I'm going to invite Roosevelt Mosley to the stage to talk to us about what it means for actuaries. Oh, that might take a... There we go. Okay, please join me in welcoming Roosevelt. There we go. Good luck.
Thank you. Thank you, Nicolette, and thank you to each of you for being here this morning. When I was asked to do this, it was probably about 7 or 8 months ago, and so I've had time to spend with the report that Justice Hayne and the Commission put out. I've had time to spend researching the Transparency Task Force and the work that Andy is doing, and I can say that it has been pretty heavy over that 6 months. And so if you didn't feel the weight of the issues that they were describing in the video or when Justice Hayne gave his presentation, that time that you've got to spend with it, that's been my time over the last 6 or 7 months. And so as Amanda was talking about alcohol, sometimes the issues that we're talking about here can drive you to drink. But let me maybe let me try and bring home sort of the reality of the point that was being made in a way that really hit home for me. And so when you think about the idea of trust, trust is defined by Oxford as the firm belief in the reliability, truth, ability, or strength in someone or something. And so when you think about the lack of trust that's been described today, what that really means is that our customers really believe that we sometimes as an industry, a lot of times as an industry, are unreliable, that we are untruthful, that we don't have the ability, are unable, or don't have the strength, are too weak to perform and to meet the expectations that they have for us. And I don't know about you, but when I think about it that way, it was very sobering, because not only do I really want to be associated with an industry that's thought of that way, I've had the opportunity to work with, to meet, and to collaborate with hundreds of actuaries over my career. And I can tell you that the vast majority of those actuaries that I have worked with, collaborated with, and met don't fit that description of being unreliable, untruthful, unable, or too weak to do what needs to be done. And so now the question becomes for us, what do we as an industry, as actuaries, need to do to begin to change that paradigm? Well, I remember this quote from years ago. I believe my mother was the first one that actually said it to me, but the idea that trust takes years to build, seconds to break, and forever to repair. And so when you think about the idea of trust, we are constantly in a state of doing one of four things. We are either building trust, we are maintaining trust, we are breaking trust, or we are repairing trust. And so the idea as we think about what it means for actuaries is, how do we help begin to shift the paradigm from the break and repair side of trust to the build and maintain side of trust? Well, there are three things that I want to leave you with in the short time I have. And I'm, as Amanda said, I'm not going to answer all the questions. Hopefully I will begin to get you to start thinking about what you can do individually and what we can do collectively to help begin change that paradigm. And those three things are remembering our customer, refocusing on our responsibility, and the third one I'll give you in a moment because that moves toward the future. So first, remembering our customer. When you think about the financial services industry, and my background has been more working traditionally in the insurance sector. And so when you think about the insurance sector, I have the opportunity to talk to a number of students in my role as president of CAS. And invariably, many of them always ask me what it is that I enjoy, what's fulfilling about being an actuary. And oftentimes, when we describe what we do as actuaries, we sort of focus on the how of what we do. We analyze data. We are very technical. We manage, we understand risk, and we help companies deal with and manage risk. But I like to focus on the outcomes, because I think the outcomes are what students and really the general public can relate to. We enable a lot of things within our society. Imagine owning a home, driving a car, starting a business, planning for retirement without the services that many of us and the companies that we work for provide. It would be significantly difficult, if not impossible. And so when we remember our customers, when we remember to refocus on those that we ultimately are serving, it will sometimes change our mindset. It will change what we think. Obviously, many of us work for different companies, and because we don't interact every day with our customer, because we don't receive the accolades from our customer, we interact with the companies that we work for. We are paid by the companies that we work for. Sometimes it can be easy to forget our ultimate customer and do things for that benefit more of our individual employers. But if we really think about it, if we remember our customer and ultimately who we are serving, that will begin to either build and maintain or rebuild the trust that we so seek to do. The second thing is refocusing on our responsibility. And you've heard this several times during the presentation today, during the presentations today. And so it isn't anything new. But as actuaries, many of the associations that we belong to, we have professional responsibilities. We have standards, we have codes that we have agreed to as we have qualified and joined these organizations that we have agreed to live up to. And so these codes, these standards cover many of the things that have been described today. And I can give you examples from the codes that I am subject to and familiar with, the codes that apply to U.S. actuaries. But the codes speak about things like honesty, integrity, that we must conduct the work that we do with skill and care, and only when qualified to do so. And so many of the things that we are supposed to do, many of the things that we should be focused on are standards that we're already subject to. And obviously, as we look back over financial services history, the actuarial history, even in the midst of these standards being applicable to many of us, oftentimes we still see examples of conduct that does not necessarily live up to these standards. And so what does that mean for us? I think it means for us that oftentimes in the busyness of life, in our day-to-day jobs, we can sometimes lose focus on the responsibilities that we have all signed up to when we become a professional actuary. But it's not just an individual responsibility. I have a responsibility to act honestly. I have a responsibility to act with integrity. But it's not just a personal responsibility, it's also a collective responsibility. The Transparency Task Force was covered in a BBC Panorama documentary that I reviewed as part of preparation for this. And in that documentary, Dame Elizabeth Gloucester, who did an investigation along the lines of what Justice Hayne did here in Australia, said something that was very profound. And again, it's very simple, but very, very profound. And what she said was, I think that, and eyes are getting bad as I get older. But essentially, it's important that people in senior positions stand up and be counted when things go wrong. And so not only is it an individual responsibility, it's a collective responsibility from the very top when things go wrong, and or before things go wrong to make sure they don't go wrong, but also from the very bottom. One of the precepts that, again, U.S. actuaries are subject to is that when we individually become aware of a violation of our code of conduct or our standards of practice, unless there is a confidential reason that we cannot, it is our duty, not an option, not a suggestion, it is our duty to actually report that violation. Now, what tends to happen in practice, not many violations get reported, not many violations actually make it to the point of either discussing with the subject actuary or reporting the disciplinary body. But if we really are going to refocus on our collective responsibility as a body of actuaries, there are things that we're going to have to do to ensure that not only our individual conduct is appropriate, but the conduct of our entire profession is appropriate. So the last thing I'll point out, and this really gets to the future, is really recognizing the opportunity that stands in front of us. If we really are remembering our customers and if we really are refocusing on our responsibility, we will recognize that as customer expectations continue to grow and change and expand, that we not only have the opportunity to not do things that break the trust, we have the opportunity to focus on providing additional customer value and actually building that trust. And I've listed here just some examples, really to just get the discussion started. One of the examples that I will give you is this idea of fairness. And again, I'll give it to you from a bit of a U.S. perspective, but what I found is that as I've talked about this idea of fairness outside of the U.S., while the issues may be different than they are in the U.S., the concept translates. Typically, when we talk about the idea of fairness, we think about it in terms of actuarial fairness. If the data supports a conclusion, then that conclusion must be fair. One of the challenges that we've been faced with as an industry, as a profession, really as a society, is the fact that the data that we analyze, the data that we have access to, sometimes has embedded potentially within it historical biases that have influenced the history, influenced the data that we analyze, and ultimately potentially influenced the outcomes that we are producing. And so over the last 3 years in the U.S. especially, there has been an increased focus from a regulatory perspective on the idea of what is fair, not just from an actuarial perspective, but really from a social perspective as well. And so what we realized as an actuarial profession, and specifically as a CAS, was rather than as some in the industry have, rather than continue to push back against this idea of social fairness, we saw it as an opportunity for us to really become engaged in the conversation and come at it really from an actuarial and analytic perspective. And so back in 2021, I believe, the CAS released the first set of research papers on fairness. And it really was, again, looking at the potential for historical biases in our society to have influenced the insurance process that we are a part of. And if that is the case, how do we uncover that, and then how do we deal with it? And so as we continue to push in this particular area, again, it provides us with an opportunity to remember our ultimate customers, remember the responsibility that we have, and potentially produce something that is of value not just for the companies that we work for, but also for society as a whole. Transparency is another aspect of trust, And it's another aspect of as the complexity of the world continues to grow, how do we ensure that there is enough transparency such that, again, the customers, the users of our actuarial services can really understand what it is that we're doing and trust that we are not doing anything inappropriate. Mitigation was a topic that was covered a bit yesterday, especially in the discussion around climate risk. Because we are experts in analyzing risk. We analyze a lot of data and a lot of information to be able to measure that risk. It only makes sense that we could look at taking the next step in how do we help society mitigate that risk. And so again, moving towards what the customer will expect is don't just charge me for the risk that I transfer to you, help me mitigate the risk that I'm transferring to you as well. And so again, if we remember our customer, refocus on our responsibility, and recognize our opportunity, we will begin to start moving this needle. And ultimately, it starts with each one of us. We can't fix this collectively until we are committed to doing it individually. So as each of us is doing that, we will be able to then be part of the process that helps rebuild the trust in the services that we provide. Thank you.